Good afternoon, and it's a pleasure to participate in today's seminar on judicial conduct. And I'd like to start by thanking Laura, Ronan, and all who've been involved in organising this important seminar and seminar series. In my brief presentation today, I'm going to look at one of the core principles of judicial conduct under the 2019 Act, and that's the principle of equality of treatment to all persons before the courts. And so I have a few slides which I'm going to run through on a whistle-stop tour of this principle and what it might mean in practice and how we might be able to give effect to it under the 2019 Act. So let's start with the 2019 Act itself. So we see reference to this principle of equal treatment in two places. First in section 7, which sets out the functions of the council. And of course, one of those functions is to promote and maintain high standards of conduct among judges, having regard to the principles of judicial conduct. And those principles are then spelled out: judicial independence, impartiality, and so on. And last but not least, the requirement to ensure equality of treatment to all persons before the courts. And of course, these principles of judicial conduct are essential for the fulfillment of one of the other functions of the council, which is to uphold public confidence in the judiciary and in the administration of justice more generally. And one of the important mechanisms for doing so is found in section 43 of the Act. That's the Judicial Conduct Committee, which the council must establish. And of course, the function of this committee is to promote and maintain the high standards of conduct among judges that we saw reference to in section 7. And we see those principles spelt out again, including, of course, the principle of equality of treatment to all persons before the courts. So what does this principle mean in practice? And I just wanted to briefly kind of run through the different elements to kind of consider what might be encompassed by it. The first element, of course, is equality of treatment. And that's a familiar concept to us in the law, both under our constitution and in our broader law in Ireland and in the EU. And underlying those different areas of law, we have, of course, different conceptions of equality, which sometimes come into tension and come to the fore in different cases. But at its core, I suppose we could say that it encompasses prohibition of certain types of discrimination, direct discrimination, but also indirect discrimination. It involves ensuring equality of treatment to all persons, but that equality of treatment may require different things in the context of certain persons and certain litigants who come to the court with different needs and different capacities. And of course, one important example of that in equality law more generally is the duty to provide reasonable accommodation for persons with disabilities where that's required. And of course, this is great practical importance when it comes to how the courts engage with disabled people in the conduct of trials and the activities of the courts more generally. Second element to note is that the equality of treatment is often understood by reference to certain protected or prohibited grounds of discrimination, such as race, sex, age, disability, and so on. Now, of course, the principle of equal treatment that we see set out in the 2019 Act is of more general application. So it's not confined to any such specific protected grounds of discrimination, but nonetheless, they may be useful in understanding when this principle of equality of treatment might come into play in practice for judges and for the operation of the courts. The second element that's important to consider is the reference to all persons. So this brings within its embrace not only litigants, but also members of the legal professions, court officials, and others who may have interactions with the court, such as witnesses, for example. And then the final element is the reference to before the courts. And of course, this signals that this principle is chiefly directed at the court process. But one interesting issue that's arisen in other jurisdictions, and of course arises in respect of other grounds of potential grounds of judicial misconduct, is whether it's confined to the actions of the judges of the judiciary in the courts themselves. And in the US, for example, there have been significant developments when it comes to extrajudicial judicial conduct, which is called into question because of its discriminatory, prejudicial nature, and so on and so forth. So there we see the different elements. But of course, that principle of equality of treatment isn't something new in the 2019 Act. There's a long pedigree of it in the Irish constitutional structure. And in the 1937 Constitution in particular, we see reference to it in Article 34 in the Judicial Declaration, which speaks of judges performing their functions without fear or favour, affection or ill will towards any man. And while the language of that section may be outdated, nonetheless, it emphasises the core nature, the fundamental nature of that principle of equality of treatment, which of course is also reflected in the equality guarantee in Article 40.1 of the Constitution and in our broader constitutional structure today in EU law, where the prohibition on discrimination is a core element of EU law, reflected today, for example, in Article 21 of the Charter of Fundamental Rights. And in our constitutional jurisprudence, we've seen great emphasis being placed on the principle of equal treatment. So the judgment of Chief Justice Denham in MD is one example of that, where Chief Justice Denham spoke of the principle as being implicit in the free and democratic nature of the state and as permeating the Constitution. In other words, it's a principle which underlies the Constitution as a whole. And one interesting practical example of how this principle may kick in the court process comes from a much older case. This is the Judicial case, which was an appeal before the Court of Criminal Appeal, in which Mr. Justice Walsh gave judgment in 1972. And in that case, the appellants were members of the traveller community. They raised as a ground of appeal that the conduct of the trial judge during the trial suggested that the fact that the applicants were itinerants, as they were called in the language that still had currency at that time, to creep into the evidence and to colour the case in such a way that they became objects of discrimination at the trial. And Mr. Justice Walsh was very quick to emphasise that if any such position was disclosed in the transcript or otherwise established to the court, the conviction would be quashed without hesitation on the grounds that it was in breach of Article 40.1 of the Constitution. So quite a far-reaching statement of principle on the part of Mr. Justice Walsh. And on the facts of the particular case, the court found that there was no hint of suspicion of discrimination on the part of the trial judge in this particular instance. So the argument was considered to be unfounded. But nonetheless, the principle has resonance. And of course, this statement of principle may be relevant when we consider the admissibility of certain complaints of judicial misconduct on this ground a little bit later. Now, the principle is well established in Ireland, but also has a much broader international resonance, as we know. And we see it reflected in the Bangalore principles in particular. And quite usefully, the Bangalore principles identify what this might mean in the practical functions of the judiciary. So first and foremost, of course, it means that judges themselves should not discriminate against particular people on what it refers to as irrelevant grounds that are not material in any way to the dispute that comes before the judges. And it gives certain examples of this, including race, sex, age, and so on and so forth. But the principles also emphasize that the duty is broader than that. It means that the judge must ensure that within the courtroom, the legal members of the legal profession, court officials, and so on, must also be held to this standard and must uphold this principle of equal treatment. And similarly, the principles emphasize that this principle can be called into question in very obvious ways. It might manifest itself in the language used by a member of the judiciary, in the conduct of the member of the judiciary, and so on, but it can also manifest itself in more subtle ways. And of course, that's a challenge in the sphere of discrimination law much more generally. When we look back in time, we see that in Ireland, we've certainly not been immune to this over the centuries. And in particular, in the 17th, 18th, 19th century, anti-Catholic prejudice in particular was rife within the Irish judiciary of the day. And I've just included here a picture of Daniel O'Connell, who in many famous trials called out this prejudice, even to the judge before whom he was appearing, with a courage that many other barristers of the day might not have had. And I think it's fair to say barristers of the present day might not have when it comes to calling out similar instances that might arise very occasionally in present circumstances. And of course, this was a problem that affected Irish people, not just here in Ireland, but also when they traveled abroad, for example, to England. And I just refer here to a study that was conducted of trials before the Old Bailey in the 18th and 19th centuries, which shows this prejudice towards Irish persons, whether they were witnesses, accused persons, or prosecutors, appearing appearing before the English court. So it's a problem that Irish people have had to contend with over time, no question about it. And of course, it's a much broader problem elsewhere. In the US, for example, complaints of systemic racial discrimination in the judiciary have been raised, including by many members of the judiciary themselves. And they include a recent study on this by the National Judicial College in the US on this slide. And more recently, we've seen similar complaints being raised about sex discrimination on the part of the judiciary against the backdrop of the Me Too movement, where women working within the judicial system have had the courage to call out unacceptable conduct on the part of members of the judiciary for whom they've been working. So here we see the debate on equal treatment among the judiciary very alive within the US context. And obviously that context is different from ours, but nonetheless, it shows how important it is not to be complacent about the protection of this value. And more closer to home in the UK, we see similar challenges. Again, even members of the judiciary saying that the system was riddled with casual discrimination, and this arising particularly in the context of the criminal justice system. And David Lammy, MP, of course, conducted an important study of racism within the criminal justice system more generally in the UK a number of years ago, which has led to certain reforms in this regard. And in Ireland, we haven't been immune from these problems. Certainly, they have not arisen in the same systemic and institutionalized ways that you see in other jurisdictions. But nonetheless, there have been many problematic instances of discrimination and overt prejudice and bias on the part of members of the judiciary over time. And I include in this slide just a number of the very high profile examples of this that have come to the fore over the years. Now, many of these are quite dated. Some of them go back to a time when perhaps Irish society was adjusting to a more diverse community and so on. But nonetheless, they raise concerns. And again, they underline the importance of not being complacent about this in practice. And in particular, one group that has faced challenges in this regard have been members of the traveller community. Just as in many other areas of Irish society, there have been some very concerning examples of discrimination and prejudice in language use and in the conduct of certain members of the judiciary in this regard. So it just, again, underlines the need for caution. And of course, prior to the coming into effect of the Judicial Council regime and the Judicial Conduct regime in particular, we didn't have effective tools to address instances of judicial misconduct in this regard. Some of them were addressed informally by way of an apology and so on, but there wasn't a formalized system that could be relied upon. And of course, now with the new regime, we do have the potential to address these issues in a more formalized way. Eunice has spoken about the concept of judicial misconduct and clearly sets a high standard for complaints to succeed. And in addition, there are admissibility requirements which may limit complaints of discrimination coming to the Judicial Conduct Committee, particularly if they're not very clear-cut or egregious examples of discrimination and prejudice on the part of the judiciary. Now, of course, the judicial conduct may play a very important role in addressing any potential breaches of the principle of equal treatment, but this is an issue which can't be dealt with through the misconduct structures alone. It requires other tools. And in particular, it requires judicial education and training on these issues. And it's really welcome to see the developments in recent months and years where a formal system of judicial training has been put in place and led by Ms. Justice Gearty at the moment, and with many others, including our chair, Mr. Justice Murray, taking part in these initiatives. And one example of this is the unconscious bias training, which was publicly referred to in recent months, and which can play a really important role in the context of the principle of equality of treatment of all persons before the courts. And of course, there is scope for the judicial conduct and ethics guidelines to address these issues, and there's provision for the council to give advice and recommendation to either an individual judge or members of the judiciary more generally. And I just want to conclude my presentation by making one modest suggestion in this regard. Under Section 42 of the Irish Human Rights and Equality Commission Act, there's a public sector equality and human rights duty on all public bodies. Now, the judiciary aren't bound by this public sector duty. The court service, on the other hand, is bound by that duty, and indeed the Judicial Council itself formally could be considered to be bound by this duty. But regardless of the fact that the judiciary itself as an institution is not bound by this principle, nonetheless, through the Judicial Council Act and this principle of equal treatment before the courts, similar values are required to be upheld. And one practical way of doing so is through the development of an equal treatment bench book. We had such a bench book apparently for a certain period of time. It requires modernization. Across the water in England and Wales, there's a highly developed equal treatment bench book which has been revised over time and which provides practical guidance for members of the judiciary, first and foremost, on how to deal with equal treatment challenges that may come before judges in the day-to-day conduct of their functions. And this bench book, which runs to many hundreds of pages now, provides very useful practical tips for members of the judiciary, but also for litigants and members of the legal profession on how challenges, whether in respect of disability, race, particular groups of community peoples in poverty and so on, should be addressed or can be addressed effectively within the court process, thereby ensuring that the principle of equal treatment can be given effect in practice, can be given concrete expression in the day-to-day activities of the court. So just to conclude, there's no doubting the fundamental nature of the principle of equal treatment and the importance that this has for the judiciary. It is something that could become the subject of judicial misconduct proceedings in inappropriate cases, but it's likely to be only in very blatant or egregious cases that it will be dealt with through that particular mechanism. And that really underlines the need for other tools to ensure that the principle of equality of treatment of all persons before the court is upheld in practice. Training and guidance can play a really important role in this regard. An equal treatment bench book could be useful not only for members of the judiciary, but also members of the legal profession and litigants themselves, so as to ensure that the principle is upheld across the system more generally. And of course, this is important for the judiciary. There's no doubt about that, but the judiciary also set the tone for the legal profession and in society more generally. So it's got a much broader importance beyond judicial conduct in the narrow sense and can play a vital role in ensuring the continued public confidence in our judiciary in Ireland. So I conclude on that note. Thank you very much for the opportunity to participate in today's session.